Hello everyone, welcome to the Canada Truth Channel where Canada, the illusion of freedom and system of control is exposed. Today's video, how the Clarity Act affects Alberta separation. Short answer, legally and lawfully, it doesn't. Let's go. So, to begin with, I'm going to say that I support this referendum movement that's happening in Alberta for a few reasons. Number one, it's motivating the people of Alberta. Number two, it's bringing public awareness in Alberta, in Canada, and all over the world for that matter. And number three, eventually the illusion of freedom and system of control is going to be exposed, unless these facts in law are presented. And disclaimer there, these facts in law cannot be presented because it shatters the entire illusion and it exposes the deliberate and deception and fraud and how they manufacture their consent to govern. Okay, the Clarity Act. An act to give effect to the requirements for clarity as set out in the opinion of the Supreme Court of Canada in the Quebec Secession Reference. Preamble. Whereas the Supreme Court of Canada has confirmed that there is no right under international law or under the Constitution of Canada for the National Assembly, Legislature, or Government of Quebec to effect the secession of Quebec from Canada unilaterally. Now, to begin with, the Supreme Court, just like the Government of Canada, rely on the Constitution Act 1867 as where they get their authority of and over, and by the consent of the people. Okay. Any paralegal, any law clerk, any law student, any law professor, any lawyer, any judge, any Supreme Court justice should have this information in 2 minutes of research. And so should the people of Canada, so they have informed consent when they're making their decisions, which they currently do not. Okay, so we click on the first endnote, and we can see right here, the enacting clause was repealed by the Statute Law Revision Act 1893. It read as follows: Be it therefore enacted and declared by the Queen's most excellent Majesty, and by and with the advice and consent of the Lords Spiritual and Temporal and Commons in this present Parliament assembled, and by the authority of the same as follows. So the enacting clause of the document where they claim to get their authority to govern was repealed in 1893. Section 2 was also repealed in 1893. Section 2, repealed by the Statute Law Revision Act, read as follows: The provisions of this act referring to Her Majesty the Queen extend also to the heirs and successors of Her Majesty, Kings and Queens of the United Kingdom of Great Britain and Ireland. The heirs and successors. The executive authority and government no longer extended to the heirs and successors of Queen Victoria, who died in 1901. It shall be lawful for the Queen, Queen Victoria, Part 3, executive power. Declaration of executive power in the Queen. The executive government and authority of and over Canada is hereby declared to continue and be vested in the Queen. Queen Victoria, who died in 1901, and as we can see, the provisions of this act no longer extended to her heirs and successors. Application of provisions referring to the Governor General. The provisions of this act referring to the Governor General extend and apply to the Governor General for the time being of Canada, or the other chief executive officer or administrator for the time being, carrying on the government of Canada on behalf and in the name of the Queen, by whatever title he is designated. Queen Victoria, who died in 1901. Now, the Governor General. As I've shown in previous videos, the Governor General is appointed by the Crown and Chancery. And the Crown and Chancery is the title holder to the land of Canada, of the Dominion of Canada, until 1931 and the Statute of Westminster. And like I've shown over and over, why in 1931 Canada chose not to exercise its full autonomy as provided for under the Statute of Westminster. And I've gone through that in previous videos. However, the Supreme Court gets their authority through the Constitution Act 1867 and associated acts written under the Constitution Act 1867, which the enacting clause was repealed in 1893, as well as the heirs and successors having executive power of and over Canada, and the executive government of and over Canada. So after the passing of the Statute of Westminster, the title to the land of Canada fell back on the provinces. The people of the provinces, all of the people of the provinces. The treaties were null and void. They just didn't tell the people of Canada. So the Supreme Court cannot allow these facts in law to be brought up in a court case. And I have never found in years of searching any court case where these issues have been brought up and addressed by any court in Canada, because they can't. Whereas any proposal relating to the breakup of a democratic state is a matter of the utmost gravity and is of fundamental importance to all its citizens. That's a true statement, but it's especially important to the government of Canada and the provinces in Canada that rely on the equalization payments and other monies from Alberta. Whereas the government of any province of Canada is entitled to consult its population by referendum on any issue and is entitled to formulate the wording of the referendum question. Here we go again with the Supreme Court. Whereas the Supreme Court of Canada has determined that the result of a referendum on the secession of a province from Canada must be free of ambiguity, both in terms of the question asked and in terms of the support it achieves, if that result is to be taken as an expression of the democratic will and would give rise to an obligation to enter into negotiations that might lead to secession. They will not take into account that all of the provinces became sovereign in 1931, December 11th, 1931. Moving right along. And whereas the Supreme Court of Canada has confirmed that in Canada, the secession of a province to be lawful would require an amendment to the Constitution of Canada, and that such an amendment would require negotiations in relation to secession involving at least the governments of all the provinces and the government of Canada, and that those negotiations would be governed by the principles of federalism, democracy, constitutionalism, and the rule of law and the protection of minorities, all the while ignoring the facts and law regarding to Canada, the Governor General, the Constitution, the Statute of Westminster, disregarding all of that. They rely on the Constitution and they claim democracy, constitutionalism, and the rule of law and the protection of minorities. The rule of law or the color of law? Because the rule of law says this. Section 7, saving for the British North America Acts and applications to the Acts to Canada. Nothing in this Act shall be deemed to apply to the repeal, amendment, or alteration of the British North America Acts 1867 to 1930, or any order, rule, regulation made thereunder. The provisions of Section 2 of this Act shall extend to laws made by any provinces of Canada and to the powers of the legislatures of such provinces. The provinces. The powers conferred by this Act upon the Parliament of Canada or upon the legislatures of the provinces shall be restricted to the enactment of laws in relation to matters within the competence of the Parliament of Canada or of any legislatures of the provinces respectively. So we know the Parliament of Canada, their foundational document, their constitution, the enacting clause was repealed in 1893. The provisions of the Constitution Act referring to Her Majesty the Queen no longer extended to the heirs and successors of Queen Victoria. All disregarded. Not to mention the Governor General fraud, which I have covered in a previous video. But in short, the Crown and Chancery, the Crown Office, a section of the Ministry of Justice, has custody of the Great Seal of the Realm and has certain administrative functions in connection with the courts and judicial process, as well as functions relating to the electoral process for the House of Commons elections, to the keeping of the roll of peerage, and to the preparation of royal documents such as warrants required to pass under the royal sign manual, fiats, letters patent, etc. The Crown and Chancery, after the Statute of Westminster, passed December 11, 1931, no longer had lawful authority or title to the land in the provinces of Canada. Yet, through deliberate deception and fraud, we still have a Governor General. Moving right along. Whereas, in light of the finding by the Supreme Court of Canada that it would be for elected representatives to determine what constitutes a clear question and what constitutes a clear majority in a referendum held in a province on secession, the House of Commons, as the only political institution elected to represent all Canadians, has an important role in identifying what constitutes a clear question and a clear majority sufficient for the Government of Canada to enter into negotiations in relation to the secession of a province from Canada. And whereas it is incumbent on the government of Canada not to enter into negotiations that might lead to the secession of a province from Canada and that could consequently entail the termination of citizenship and other rights that Canadian citizens resident in the province enjoy as full participants in Canada unless the population of that province has clearly expressed its democratic will that the province secede from Canada. That one's funny as well, because the rights that they're talking about have been trampled by the government of Canada despite Supreme Court decisions. So, once again, can a government based on deliberate deception and fraud be trusted to act legally, lawfully, and honorably in regards to Alberta secession? Once again, after seeing this information, what do you think? So, let's take a closer look. The House of Commons shall consider the question. Considerations. In consideration the clarity of a referendum question, the House of Commons shall consider whether the question would result in clear expression. Where no clear expression of will. For the purpose of subsection 3, a clear expression of the will of the population of a province that province ceased to be part of Canada could not result from a referendum question that merely focused on a mandate to negotiate without soliciting a direct expression of the will of the population of that province, whether the province should cease to be part of Canada, or a referendum question that envisages other possibilities in addition to secession of the province from Canada, such as economic, political arrangements with Canada that obstruct a direct expression of the will of the population of that province on whether the province should cease to be part of Canada. Other views to be considered. So, legislative assembly. Any legislative assembly in any province or territory in Canada. Any formal statements or resolutions by the Senate or by the representatives of Aboriginal peoples of Canada, especially those in a province whose government is proposing the referendum secession on, and any other views it considers relevant. So already there's been First Nation formal objections and statements put forth, even though if you read the treaties, which I've done a video on, see what the treaties actually say in 5 minutes, you will know the truth. However, the Supreme Court and the Government of Canada, nor the First Nation people, I doubt, will acknowledge these truths. No negotiations if question not clear. The Government of Canada shall not enter into negotiations on terms on which a province might cease to be part of Canada if the House of Commons determines, pursuant to this section, that a referendum question is not clear and for that reason would not result in a clear expression of the will of the population of that province, whether the province should cease to be part of Canada. Again, it's up to the House of Commons. House of Commons to consider whether there is a clear will to secede. The House of Commons, once again, given the referendum, they'll say, well, this and that, yeah, all these people didn't vote, so this doesn't count, or whatever deceptive, illegal, unlawful excuses they're going to give. Other views to be considered. Once again, formal statements, resolutions. It's easy to see what those treaties say. And it's easy to see how the people of Canada and First Nation people are being deceived. Constitutional amendments. It's recognized that there is no right under the Constitution of Canada to effect the secession of a province from Canada unilaterally, and that therefore an amendment to the Constitution of Canada would be required for any province to secede from Canada, which in turn would require negotiations involving at least the governments of all the provinces and the governments of Canada. And once again, the government of Canada has everything to lose and nothing to gain from Alberta's secession. The other provinces of Canada have everything to lose and nothing to gain with Alberta's secession. So, despite the fact that the Constitution, the enacting clause, was repealed in 1893, and the legal and lawful executive government and authority of and over Canada no longer applied to the heirs and successors of Her Majesty the Queen. And after the passing of the Statute of Westminster, despite all these other anomalies, despite this passing, number 2, the validity of laws made by Parliament of a Dominion. The Parliament of a Dominion. The Colonial Laws Validity Act 1865 shall not apply to any law made after the commencement of this act by the Parliament of a Dominion. No law and no provision of any law made after the commencement of this act by the Parliament of a Dominion shall be void or inoperative on the grounds that's repugnant to the law of England or to any provisions of any existing or future Act of Parliament of the United Kingdom, or to any order, rule, regulation made under any such act, and the powers of the Parliament of a Dominion shall include the power to repeal or amend any such act, order, rule, regulation insofar as the same as part of the law of the Dominion. Number 3, power of Parliament of Dominion to legislate extraterritorially. It is hereby declared an enactment that the Parliament of a Dominion has full powers to make laws having extraterritorial operations. The Parliament of a Dominion, as we saw, includes the legislatures of the provinces. So all of these efforts, I believe, are going to be crushed through deliberate deception and fraud, through the relying on the Constitution Act, the dead-in-law Constitution Act, ignoring the Statute of Westminster, ignoring the fact that the Crown and Chancery no longer had lawful title to the land of the provinces and no longer had lawful authority to extend any letters patent. Despite all these facts, this effort is going to go forward, which I'm going to support because I believe it's the only way that people are going to admit that Canada is an illusion, the illusion of freedom and a system of control. And until people acknowledge the facts, first learn, and then acknowledge the facts in law, which myself and others are trying to show you, until that happens, relying on a government, any government, to come and save us is not going to happen. The entire system was designed to protect the government from the people. period. If you would like a brief overview of the entire situation of Canada, you can go to the Canada the Illusion channel. I will leave a link in the description. And watch Canada the Illusion. It's in under 50 minutes. It gives you an overview, and using the links provided on The Myth is Canada and the links I provide in my videos, you can see for yourself, you can show others. Without developing your own level of knowledge and understanding, you can't make informed decisions because their whole system is based on deliberate deception and fraud. So please share this information, subscribe to the channel, like the video. The channel is being heavily suppressed. Thanks for watching.